Felony process. In a felony case, there are generally three phases. The first phase begins with the arraignment. An arraignment is when you and your attorney appear in court and are handed a complaint that includes a statement of the charges against you. Along with that complaint is the discovery, which are the reports in your case. At the arraignment, we will enter a plea of not guilty and also argue, if necessary, an OR release, or a reduction in bail. OR stands for release on your own recognizance. In other words, you're promised to appear at your next court date without the necessity of the judge ordering a bail amount. In some instances, it may be beneficial to continue this entire arraignment process to a future date. After the arraignment, a date will be set for a preliminary hearing setting. A preliminary hearing setting date is when your attorney has the opportunity to attempt to resolve the case. This process is called plea bargaining. A plea bargain is a compromise or an agreement which results in a settlement of your case. Some judges will allow several preliminary hearing setting dates for this purpose. Other judges will only grant one or possibly two preliminary hearing setting dates. If for any reason your case is not resolved during the preliminary hearing setting date, your case will be set for what is called the preliminary hearing. The preliminary hearing is a probable cause hearing. You, your attorney, the district attorney, and the district attorney's investigating officer will be present. The judge will look to the district attorney to present some evidence which will give the judge a strong suspicion that you have committed the offenses that you are accused of by the district attorney. The district attorney will call their witnesses and they will tell their story. Your attorney will be able to cross-examine those witnesses in order to accomplish certain goals. The number one goal for your attorney at the preliminary hearing would be to get the charges dismissed. This, however, is very rare due to the fact that the judge only has to have a strong suspicion that you committed each and every element of the crime that you are accused of. Unlike a jury trial where all 12 jurors would have to believe beyond a reasonable doubt each and every element of the crime, a much higher standard of proof. Every once in a while at a preliminary hearing, you can get the charges completely dismissed. The number two goal at the preliminary hearing is to test the strength of the prosecution's case. This is very important because you will learn where the weaknesses are. The number three goal at the preliminary hearing is to weaken the prosecution's case, which can often be accomplished by exposing inconsistencies and implausibilities in their case. The fourth goal would be to set up your defenses to the case. At the end of the preliminary hearing, your attorney will make a motion to dismiss for the insufficiency of the evidence and in many cases argue to the judge why the charges should be dismissed. Again, it is very rare that a judge will dismiss the charges at the preliminary hearing. However, quite often, a count, one of possibly several allegations, will be not proven and therefore dismissed. At the end of the preliminary hearing, the judge will bind the defendant over to the second phase. At the second phase, there will be a second arraignment. Please recall the original arraignment when you and your attorney were before the court at the beginning of phase one. The reason for the second arraignment is due to the fact that the judge has passed the case on to another jurisdiction, and at the preliminary hearing, some of the accusations, charges, or counts may have been dismissed. The charging document at the first arraignment and the first phase is called a complaint, which simply states what you have been accused of. In phase two, at the second arraignment, the charging document is called an information. The information also tells you what you are being accused of. At the second arraignment, you will enter a plea of not guilty. After your plea of not guilty, there will be a series of pretrial dates. These pretrial dates are designed to do very much what the preliminary hearing setting dates did, in Phase 1, which was to attempt to resolve the case by way of plea bargain, compromise, or settlement. Also in Phase 2, legal motions will be prepared and filed. Motions consist of discovery motions which make sure that the prosecution provides all evidence and documents that they have to your attorney. There may be a 1538.5 motion, which is a search and seizure motion. There may be a 995 motion, which is a motion to let the judge in Phase 2 know that there were some legal missteps by the judge in the preliminary hearing phase and that you should not have been bound over or held on these particular charges that are now before the judge. These, along with other types of motions, can be run during the second phase. If for some reason you cannot resolve the case in the second phase, we move to the third phase, which is a trial. A trial is where 12 people from the community are selected to decide guilt or innocence in your case. Every once in a while, we may waive the jury and let a judge decide the guilt or innocence in your case. This is, however, very rare. In a jury trial, all 12 jurors will have to believe beyond a reasonable doubt that you are guilty of each and every element of each and every crime that you are accused of. There are 3 possible outcomes for a jury trial. Not guilty, which is commonly referred to as an acquittal. This exonerates you of any wrongdoing in the case that the prosecution brought against you. The second is a guilty verdict. Remember, all 12 members of the jury would have to unanimously agree that you are guilty of each and every element of the crime beyond a reasonable doubt. If the jury finds you guilty, there will be a sentencing where a judge determines what punishment is appropriate in your case. The third is what is referred to as a mistrial, which is where all 12 jurors cannot agree upon your guilt or innocence. If the jury cannot agree unanimously upon guilt or innocence, then the judge will declare a mistrial, and the district attorney can start the trial process over as if it had never occurred. This felony process, from beginning to end, could take anywhere from several months up to a year, depending on the charges. It is usually to the benefit of the accused to have as much time as possible in order to develop their case.